Hello and good morning, everyone, to the panel on fundamental rights implications of recent trends in digital forensics. I'm happy to see you, although I cannot actually see you, but see you here at our panel in stream number 3. I would prefer to be able to see all of you. I guess it's the same for the audience or the speakers, but everyone on the organizational side is doing their best so that you have an experience, at least topic-wise, which is just as good as if we all would be meeting in Brussels. My name is Mark Cole. I'm a professor in media and telecommunication law at the University of Luxembourg, and at the same time, I'm director for academic affairs at the Institute of European Media Law in Saarbrücken. And as the latter, we do a lot of data protection research there, which brought me to the CPDB many years ago. And I'm happy to say that this panel this morning is the 6th edition of a University of Luxembourg panel at the conference, and I'm even more happy to say that I think we didn't only target a very interesting topic for today's panel, but we have a row of very, very interesting and knowledgeable speakers. I will introduce them a little bit more to you in a moment. What you will realize is that our speakers come from both academia and the practice, and in one case it's even a hybrid form of academia and practice at the same time. And for me, that is one of the big advantages and true advantages of CPDB, that we bring together the researchers and the ones that actually have to live up to the challenges in practice. What are we going to talk about this morning? Recent trends in what we call digital forensics. Obviously, this raises two elements, this topic overall. One is we have an increased use of machine learning, of artificial intelligence, of computer assistance systems at law enforcement agencies, which make probably the work easier, maybe more efficient, maybe is even indispensable that such technology is being used. But at the same time, they pose challenges in terms of fundamental rights. So whenever machines get involved, the question is, what's the machine-human interaction? Who takes final decisions? What about the balancing between efficiency of tools versus potential fundamental rights implications? Who actually still knows how these new tools work? Who has the insights that are necessary to be able to judge whether they can lead to unbiased results, or at least not lead the law enforcement agencies to go into the wrong direction? And those questions we want to tackle today. Where do we stand both in terms of practice and also the regulatory framework? Is it difficult for police to actually use these tools, or is there a regulatory setting which allows for it? What about the opportunities, the benefits balanced against potential fundamental rights implications? And in order to do so, we will have first Georgios Bouchagiar speaking. I will introduce him in a moment a little bit more in detail. He is from the University of Luxembourg, a doctoral researcher who is exactly dealing with this topic of digital forensics. We will then have Markus Hartmann from the Central Cybercrime Department in North Rhine-Westphalia in Germany. And after that, Catherine van der Heyning, who is both from the University of Antwerp, where she's professor, and at the same time public prosecutor. I will talk to each of them a little bit more in detail before they give their presentations. Our last speaker that was foreseen, Erik Modin from the Danish Police Academy, had to cancel on short notice, but I am sure there is going to be a fruitful discussion possible anyway with the presentations of the three speakers. As with all other panels, we will first have presentations, and then there will be a possibility for a Q&A afterwards, where you can also pose questions in the chat, and I will then communicate them to the speakers. Having said that, I will briefly give you a bit more of background to Georgios and his position. He's mainly looking at DNI phenotyping, and what you will see this morning in the presentations is that we will not only look at one new digital forensics tool, but different types of tools. So the first one we will hear about a little bit more is, what is DNI phenotyping, how does it work, and especially is that problematic from a legal perspective. He's got a law degree from Athens Law School, but he also has a Master in Science in Information Technology. So he actually can understand as a lawyer what we're talking about when we talk about technical aspects, which I think is very important today. And he is now working, as I said, as a doctoral researcher at the University of Luxembourg under the supervision of a colleague of mine in a joint research project with VUB in Brussels, and he's been presenting on this issue quite a lot. So I think we will be interested in hearing from him in about 10 minutes what we need to know about DNA phenotyping. Georgios, the floor is yours.
Thank you very much. So I will address the interference of DNA phenotyping implementations in criminal investigations with the right to privacy. Phenotyping is a technology that uses DNA to forecast the potential genetic characteristics of a DNA owner. Now, what does this mean in the context of criminal investigations? This technology analyzes DNA to foretell the potential genetic aspects of the unknown. For example, the person from whom the crime scene sample originates. For instance, we can imagine a crime scene where we may have a person, let us say Stella, the murderer, and this person has just killed an individual, and we also have Lydia, the eyewitness, who notices a devil tattoo on the hand of the murderer. Now the authorities may arrive at the crime scene, and they may find a blood sample. So this could belong to the murderer. Now they can apply phenotyping so they can be informed about the likelihood that the person they are looking for may be green-eyed, blonde, white-skinned, with a propensity for homosexuality, or suffering from a concrete genetic disease. So now the authorities may look for people who have a devil tattoo on the hand, because that was the testimony of Lydia, and they can also look for people who may share the characteristics predicted by the technology. So here we have a group of suspects which is created by evidence, the testimony of Lydia, and which is reduced by phenotyping. So the goal here is to find the unknown, and this through the narrowing down of the group of suspects. What follows, the authorities may stop and search an individual, they may arrest a person, and they can then apply traditional DNA techniques. For example, they can take the sample of a person and they can try to match it to the crime scene sample. What is the interference of this technology with the right to privacy? A person may be approached or subjected to DNA testing. She may have a disease that she has the right not to know. And DNA phenotyping related elements could be correlated with personal data, which are stored on databases. Now, a parenthesis here, is this a type of surveillance? Surveillance has traditionally been about control. However, contemporary forms of surveillance may include the endeavor to establish identity or to gain knowledge or to create or obtain individual or group data. Now, phenotyping can be seen as a technology which contributes to the controlling of the unknown through, for example, stopping, searching, as a technology which contributes to establishment of identity, for instance, through the reduction of the group of suspects or through the facilitation of the matching task. It can be seen as a technology which is aimed at deriving information about, for instance, a disease which is unknown to the individual concerned, or a technology which is aimed at creating group data like the blue-eyed. Now, this technology is regulated by concrete laws in the Netherlands, Germany, Slovakia, and it is practiced without concrete laws in a number of jurisdictions such as Spain or the UK. Now, I will try to subject this technology to the legality, legitimacy, necessity assessment, as we know this assessment from case law of the European. I will focus on Article 8, which is the right to privacy. Paragraph 1 comes with the subject matter. Everyone has the right to privacy. And paragraph 2 comes with the rule, which is any interference shall be prohibited, and the exception which entails this legality, legitimacy, and necessity testing. So first, the interference with the right to privacy, which is in principle prohibited. First of all, it is in accordance with the law. And here, the court requires a number of legality elements to be met. So we need a domestic legal basis, which is accessible. So here, people must be aware of the law, which is applicable to a particular case. It has to be foreseeable, the consequences or the conditions in which public authorities have the power to resort to the measure. It has to be precise, detailed. This means that the law must sufficiently indicate the scope or manner of exercise of discretion, and it has to be compliant with the rule of law. Moreover, we need concrete rules on the categories of people who are liable to be subjected to the measure, the nature of the offenses that could trigger the measure. We also need limitations on duration. We need conditions regarding data processing or sharing or deleting data. We need ex-ante supervision, notification, as well as effective remedies. And all these are legality elements. Now, I move on to legitimacy. The interference, which is in accordance with the law, must moreover be at the service of a concrete purpose, which is mentioned in paragraph 2 of Article 8, such as the protection of national security or public safety, or the prevention of crime. And this is legitimacy. And then we have the interference, which is in accordance with the law and which is at the service of a concrete purpose, must moreover be necessary in a democratic society. So here, the court addresses a number of questions, including, is there a pressing social need? Are there relevant and sufficient reasons invoked by the authorities to justify the interference? Is the interference a suitable response to the pressing social need? And is it proportionate to the goal pursued? And this proportionality assessment could also involve a balancing exercise, individual versus the public interest, and a quest for legal safeguards. So how could phenotyping pass this legality, legitimacy, and necessity assessment? First, legality. Phenotyping may be practiced without concrete laws. So here we could lack the very domestic legal basis. Could we rely upon traditional DNA provisions? Well, in light of the new elements introduced by phenotyping, the forecasting of the potential genetic aspects of the unknown, it could be argued that traditional DNA provisions would not meet adequate standards of foreseeability or precision. Then, what about non-statutory law, like case, that we would at least demand settled case law? So it could be argued that for the legality test passed, we would need sufficient accessibility and foreseeability, as well as precision and detailedness of the law. Now, on legitimacy, phenotyping can be seen as the technology which aims to find the unknown. And this could be seen as contributing to the fight against crime or to the protection of national security or public safety. And last, we have necessity. So we could ask whether finding the unknown can be seen as a pressing social need. And I started my presentation with an example of a murder. So it seems that there is a pressing social need to find the unknown. However, it could be argued that phenotyping implementations could be seen as an endeavor of the state to render anonymity a myth. Then there is suitability of phenotyping, and this could be met if we had strong legal safeguards that could protect against potential arbitrariness. On relevance of the reasons invoked by the authorities to justify the interference, well, here we could ask whether the results of the technology constitute facts, they have probative value, and maybe we could focus on the capacity of the technology to learn from data, to be trained in data, so as to provide for experience-based results. Then sufficiency of the reasons invoked by the authorities to justify interference, we could ask whether this technology is accepted by the relevant scientific community. Last, there is proportionality, and here we could have a review mechanism in the sense of specialized tribunals who could be assisted by experts, and they could engage in ad hoc proportionality assessments. So that was it. Thank you very much, and I'm looking forward to the Q&A.
Thanks a lot, Georgios. I think already your presentation clearly illustrated the problem of having possibilities versus how to apply them in practice and where the limitations are. It reminded me actually a little bit of the endless saga, which again has also been topic of some panels here about data retention, about collecting information on a broad basis to potentially have information that can then be used for investigations. Having said that, I hope and possibly it is working now. I just learned while you were presenting that Erik Modin actually did not have to cancel on short notice, but was put into the wrong room, I believe. Erik, if that's the case, I didn't want to suggest that we do not want to hear your presentation. So hopefully you are online now and can then, after Markus and Catherine have given their perspectives, join. So we will continue as we planned, and then hopefully in the next 15 minutes or so, we will know that you can also participate. Now we would like to move a little bit from the academic perspective on one specific tool that one can use, like Georgios presented, to a more insider practice-oriented perspective of Markus Hartmann. As I mentioned before, he is not only a senior prosecutor, but he's head of the what we call in Germany the ZAK, the Central Cybercrime Department in North Rhine-Westphalia. He will talk more about that in his own presentation. I think it is very important because this is an example of a unit that was developed on the fly, if I may say so, over the last couple of years to actually bundle the knowledge on how to tackle cybercrime. And I think it's a model which has been looked at in a lot of other places as well. That's why Markus is a frequent speaker, a much sought after speaker at conferences that deal with this topic. And if I may say so, it's an insider perspective. Markus is also in the board of the German EDV Gerichtstag, which, if you want, is something like an e-justice association that takes care since many decades about how to use computers in justice and also law enforcement. And also there we appreciate his work a lot. Markus, we're looking forward to your presentation.
Yeah, thank you very much for the kind introduction. And yes, that's actually what I would like to do. I would like to take you with me and give you a short overview about forensic tools and how artificial intelligence already today is changing the landscape of what law enforcement can do in this field. But as you mentioned, I think it's quite vital to know where I'm coming from and the organization of my team. The organization of the ZAK NRW reflects a little bit on the challenges that we as a prosecutor are facing in the field of digital forensics. So let me give you a short overview about my team and the fields we are working in. Originally, the Central Cybercrime Department started, as the name implies, purely focusing on what we call traditional cybercrime. Major hacking events, cyber attacks on critical infrastructure. But over the years, a lot of additional topics came up, topics that are not strictly cybercrime, but that are related to the methods of online investigations. For example, we are now also in charge of tackling digital hate crime. We are also in charge of prosecuting online child abuse and child pornography. And what makes our team special is that not only within the field of prosecution and investigations, we have specialized colleagues, but also in the field of research and development. It is quite unusual for a prosecutor's office, at least in Germany, to be also responsible for non-investigation related issues, more general topics like research and development. The idea behind that is that online investigation, that cybercrime investigations are more or less new grounds that we have to develop the tools for. And we would rather not rely on that what the market provides. Of course, we're using a whole variety of tools that are available for law enforcement agencies from commercial vendors. But to be really able to tackle those issues that we're facing in digital forensics and to have tools that comply with the German regulatory framework, we more or less have to take the burden of research and development on ourselves. So even if it is unusual for a prosecutor's office to do so, I'm quite happy that some years ago we took the decision to do so. And I would like to go to a few of the projects that we have come up with and to, on one side, explain why it's useful for the investigation, and on the other side, also to be open about the fundamental rights and privacy issues this has. So let's start with one topic, with one insight into what I would like to call law enforcement real life. I'm sure a lot of you will consider my arguments a little bit to be a bit much on the side of a killer argument, but nonetheless, I would like to start with the topic of online child sexual abuse and child pornography. As said, my team recently gained the responsibility for tackling online child sexual abuse and child pornography, and investigating this field really shows that we are not talking about a niche problem. We, in our investigations, came up with evidence that online chat groups, online chat platforms have thousands of participants exchanging child pornography pictures, child pornography video, exchanging their views, and thus, well, like we discussed in the political field, forming filter bubbles, which in our view support and help realizing not only thinking about child pornography, but also committing real sexual abuse. So if you just look at the sheer numbers, I would like to point your focus onto the number from a press release we recently had. Only in one case we are investigating, the number of suspects that are participating in online chats about child pornography and child sexual abuse comes up to about 30,000 suspects. I'm quite glad that not only police and prosecutors have started to get serious about this issue, but also the political field. The European Commission has shown very great interest in improving the legal situation. There have been a lot of forums and discussions lately, whether the e-evidence situation in Europe, whether the Digital Services Act, whether all the new regulatory frameworks can also contribute to better combating child sexual abuse. And I think it's a good statement from the Commission that the fight against child sexual abuse is now considered to be a top priority. But let's go back to what I promised in the beginning, the law enforcement real life. What are the real challenges? Actually, the challenges are quite easy. The first challenge is, if you're today raiding somebody's home, it's not that you're seizing just one hard disk, just one computer. If you just reflect on your personal situation, you will, I think, agree with me that it's about terabytes of data that you seize at an individual suspect's home. So the real challenge is, do we manage to go through all the evidence that we are collecting in time to A, really realize what is going on, and are there still children in danger of getting abused? And B, also with the perspective of the rights of the suspect, do we have the right tools to go through all evidence in time in order to not be forced to keep all the digital devices of a suspect for years and years, even in a state that there has not been any conviction of this individual person? So I think, more or less, there's an obligation for the law enforcement and prosecution side to come up with better solutions than manually reviewing the data, having a police officer manually go through the evidence. The solution might be, let me stress it, might be, I'm not sure at the moment because there's still a lot of research to be done. But one of the solutions really might be to develop, with the help of artificial intelligence and machine learning, better tools that assist prosecutors and police officers in evaluating evidence in a timely manner. And as I said, a research and development department does exactly that. We teamed together with researchers from Saarbrücken University and with researchers from Microsoft as our business partner and several other people, and came up with a specially trained artificial intelligence that is capable of identifying and categorizing child pornography and ordinary pornography pictures in huge amounts of evidence, and that is capable of leveraging the computing power of the cloud through an abstraction layer, which pre-processes images on an on-premises basis and then transfers them for the training and analysis to a cloud instance. That raises a lot of questions, and it took us more than a year to decide on the legal basis and the technical basis to do so. But I'm happy to announce that hopefully within the upcoming 3, 4, maybe 5 to 6 weeks, we will show a working prototype which complies with all legal and technical issues we have. So let me leave for a moment the field of evidence from data storage and move on to another aspect. As I said, 30,000 subjects engaging in child pornography chats online. We have to go through all these chats because there might be criminal acts in these. We have to read them, we have to analyze them, we have to identify suspects by reading and analyzing those chats. 30,000 participants in a chat pose an nearly impossible question to tackle manually. So we are also looking at artificial intelligence instruments with proper understanding, semantic understanding of what has been said in the chat to pre-analyze this material of evidence. Let's leave the field of child pornography and just broaden the range of artificial intelligence applications, because there's a common pattern among all these use cases. Law enforcement nowadays is confronted with a huge sheer amount of evidence that we have, and the issue is not getting and seizing evidence. The issue is understanding and categorizing it in time. The same applies also to the field of digital hate crime. The recent events in the US politics have put another new focus on how we deal with what has been said online. So artificial intelligence might also be one of the methods to go to. And this is a field which is, well, extraordinarily sensitive, because here we tackle the whole question of free speech and very fundamental user rights. The last example I would like to present to you is the field of selling drugs online, not in the understanding of Netflix series, but in the understanding of real life. Well, drug trafficking has moved from the streets to online web shops and online vendors basis. And we, of course, go for the vendors. We're trying to identify them, we're trying to shut down the platforms, and we are quite efficient in doing so. But that also leads to seizing databases of people who have bought drugs online. And at least under German law, there are a lot of decisions to make. If somebody has just bought a very slight amount of drugs, a very small amount, we might decide not to prosecute him or her. If it's a huge amount of drugs bought online, we have to do so. So the question for us is, on a very practical basis, can we come up with a robo-prosecutor who pre-processes, who gets all the information from the databases about the amount of drugs bought online, who gets all the information about prior convictions, for example, about what we as a prosecutor's office know about individual suspects, and who at least pre-processes and predefines what has to be done in the next prosecutorial steps. I would like to stress that we are talking about pre-processing and not automatic decision, because in the end, my belief is that these are all tools to aid investigations. The real decisions always have to be taken by humans. And if there's one message that you're taking away from my presentation today, then I would like to stress then it's the top priority of all prosecutors to strike the balance between fire and ice, to strike the balance between data protection and being able to protect those affected by online harms and online crimes. I can assure you that nearly all of the discussions when developing new tools are exactly in this field. What can we do? What is allowed on a legal basis? And what are the implications, both for those affected by our prosecution and those that our legal mission is to defend? So it's quite a difficult topic, but I think that with the help of academics, with the help of the broader community, we finally will be able to come up with good technical and also good legal solutions. Thank you for your interest, and I will be happy to answer all of your questions.
Thank you very much, Markus. While the screen goes back on full view, we can now say hello to Erik. Erik, hello. Sorry for not having had you in the panel, but it's great that you're here now. We will go ahead as planned with Catherine, and then Erik will give his perspective as last panelist. But before I do that, Markus, I would like to thank you for two elements, not only giving us a very good overview, but reassuring us on two things. One is the police is not in the Stone Age, which on the one hand is good to hear, because sometimes there is this image that crime is always faster than the law enforcement agencies. But the law enforcement agencies are trying to build up a robust response mechanism, I would call it, the way you present it. But the second element, and that's important for our discussion afterwards, is that you're not doing so just from the perspective of efficiency of tools that you're trying to develop, but already in light of fundamental rights aspects or striking the right balance. And talking about that, striking the right balance with fundamental rights, it's a perfect bridge to Catherine. Catherine van der Heyning, as I said before, is on the one hand professor at the University of Antwerp and professor in European fundamental rights. And I guess it is nearly like being Dr. Jekyll and Mr. Hyde, or in this case, Mrs. Hyde, to have both that and a public prosecutor function that you do in your daily life as well. But that's provocative, because actually it's maybe the perfect example of how it should be, that the public prosecutor has also the thinking of the fundamental rights in the daily work. This, as a more humorous perspective on it, I think really it is going to be very interesting to hear from you how this plays out in the real life of a public prosecutor, because like Markus also indicated, it's of nobody's benefit if tools are developed which then cannot be used, because at the end they would lead to a negative outcome in a court case, because defense could pick on that. You have a previous life also as defense lawyer, or have taken a perspective in your research on how criminal law and justice impact defense rights. So I really think it's going to be highly, highly interesting to see your perspective. You work not only at the University of Antwerp and as a public prosecutor, but you're also very active in international fora, also at the United Nations, where you work as an expert for the Human Rights Council. So having said all of that, we have high expectations and looking forward to your presentation. Catherine, go ahead.
Yeah. Thank you very much, and thank you for having me here. It's always very much a pleasure and a privilege to be speaking at CPDP. Of course, I need to add the caveat, which you probably also expect, which is I speak in my personal capacity. I don't speak for the public prosecution, of course. And I do try to avoid schizophrenia in my work, meaning that I am taking actually fundamental rights also into perspective when I'm working as a public prosecutor. And as a public prosecutor, you can always think of, when we come with a case to the court, can it be picked apart by the defense? But you can also already take a perspective from rights of defense when you're actually prosecuting. And I think the previous speaker already very well indicated that what we're doing at a day-to-day basis is balancing data protection, privacy on the one hand, but on the other hand, also protecting vulnerable people. And of course, child pornography is a very clear example, but there are also less spectacular examples of people who need to be protected because they are clear targets online. What I'm going to do in my presentation is really put out those challenges for us today. And some of the presentations for me still are a very far future for example, Belgian prosecution, but also for, I think, the vast part of law enforcement in a lot of countries in the European Union, but also, of course, around the globe. There's some parts of law enforcement that are very far in using digital forensics, but for the vast part of us, it's still very much basics where we depend much on third parties, such as internet service providers or mobile communication operators, or we depend on open sources. And that as well brings some challenges, because we so much focus on the future of digital forensics and very advanced possibilities of digital forensics, and truly also the challenges to fundamental rights and rights of defense and data protection, that we sometimes forget how we work today. And we should also take into perspective whether digital forensics to fundamental rights are not an opportunity and an improvement as well as to how we are working today. So let me first start with, for me, the threat, of course, there is to fundamental rights. I think that one is very clear, and there are two main issues that we should take into account. The first one is that we can no longer rely on the evidence that we're presenting in court, meaning that actually no one understands how it came about, what the chain of custody is of the evidence, and then no one can go back to the raw data, because in the end, only on the basis of the raw data, the initial data, you can check whether the data are reliable, authentic, and whether it actually proves what we're stating in court. So that's the first main challenge for me. The second challenge is for the defense as well, whether they can actually access all the evidence that's provided, and whether they actually can also counter-argue with the evidence that we are presenting. And those are, for me, the two main challenges when we're talking about digital forensics. And we should also always take into account that transparency, accountability, and reliability of data should be key for the future. So then if we go to picking apart more in, and now, can you please go back one slide for me? Yes. So the first major issue in law enforcement is that we have invested actually in cybercrime units, as you've seen. Those cybercrime units are very advanced. They're very well trained. They have police officers who very well know their job. They have prosecutors who very well know their job. And actually, I'm working as well in one of the specialized units in our region where we focus on cybercrime. And that's all very well for those specialized cases in cybercrime. However, today, 90% or even more in the cases that we encounter, digital devices or digital means are being used for the crime. And so in that perspective, what we are seeing, we have those police officers who are super trained and super good in chain of custody, who know all the main criteria they should take into account. But on the other hand, the vast part of the cases, what we call still the general criminal cases, are that with police officers who are not always trained and who do not always know what to do with mobile devices or with forensics, do not always know all the standards of digital forensics, do not know which open sources are reliable or not reliable. But there are too many cases really to put everything to specialized forces. So what we really need is a mainstreaming of knowledge on digital forensics, on digital investigation to all police officers. And that will help, of course, fundamental rights and rights of defense reliability, but it will also help law enforcement, because sometimes now we get a file where it's simply too late. because if the law, the police officer who saw the victim the first day would have asked the right questions and would have gathered the right evidence, we could have done more because we would have been faster than today. And then today, now, sometimes we get a file, we need to send it back because we don't have the evidence we need to actually have a useful prosecution investigation. And so I can agree actually with the quote that is put online there, that if we don't train, if we don't mainstream our police officers, that we will run into problems in the general crime investigations. And so that our preconceived idea of we need to have a cybercrime unit and then we have the rest, I think it does no longer work. We need to have a cybercrime unit for the most specialized cases. And the German example is fantastic. We also have development of standards and tools and ideas. I think that's really, I mean, that's how it should be. But on the other hand, we shouldn't forget that the mainstreaming of knowledge should be our priority. So that's for me the first challenge. The second challenge, of course, is that we are starting to use digital forensics, and actually some of the enterprise, some of the firms that are developing digital forensic are quite aggressive in promoting their tools. And so you are offered all these kind of tools to use in digital investigation. However, they are less transparent on how it actually functions and how well it functions. And I also think at this moment, there's not enough sharing of and transparency in those digital forensic tools that are being offered on the market. And so obviously there is the threat that because we're so overwhelmed by cases and less spectacular, but all those phishing cases, I mean, those are piles and piles of cases, which we can't, we can't process them any longer on a human police officer to police officer, prosecutor to prosecutor basis, because it's just too much. There we could actually be really helped by artificial intelligence, by good digital forensics. But there is the real threat that if we don't know how good the product is, how reliable the product is, we will run into miscarriage of justice. So what we really need are standards, standards of certification of those products before we use them in actual cases. And of course, you can have test cases and product cases, and those are set apart. But if we're really going to use those digital forensics devices in day-to-day practice, we need standards. And I fully agree with the previous speaker that all those devices and all those products, I mean, those are the satellites. They help, but the human perspective and human assessment of police, of prosecutors, of judges should remain the sun, should remain central. And these are there to help us and to make it feasible, but we shouldn't rely on them too much, definitely as long as there are no standards. The third challenge then for me is how we're working today. Today, we rely mostly actually on third parties and private third parties. We rely on internet service providers, on telecom operators, sometimes other third parties who provide us with data. And as probably many of you have seen, there was a huge problem in Denmark where they encountered that the cell phone evidence they used in prosecution was actually flawed. It was flawed on the basis, one of the device they were using, the software they were using, who was making some miscalculations. But also there was a second problem, and that second problem is even more problematic because it applies to almost all member states of the European Union, which is the manner in which telecom operators actually provide us with data. Often they already make an analysis and they provide us with that analysis of data. But what we actually need for prosecution, but also for the defense, are the raw data. And we should be very reminded that we always get the raw data in order for us to check the reliability and the authenticity, but also for transparency reasons. But as those operators state, and which is also correct, of course, is that they say, well, our functioning is based on providing the service to the clients. So making sure that their data are distributed as fast as possible. Communication is as fast as possible and as stable as possible. And you are asking as prosecution for those data, which were never developed or tools were never developed for investigation purposes. And so there as well, as we are working today, we're also running into problems with authenticity. And so there as well, we need better standards as we are working with with our third parties, what the standards actually are and what we need and how we want them to be provided. And that's the same problem we're running as well when we're working trans-border, that often if we're asking data from another country, we're not getting the raw data. And that's something that we should really press on, because it's only the raw data that really will help us to prove in court that the data are authentic. That's for the prosecution, but also, of course, to avoid miscarriage of justice, and that we are sure that we're having the person before us who can actually be connected to the data that we are using. And then I'm coming to the last challenge, which is maybe more a theoretic point I'm making. And I want to refer back to a concurring opinion of Judge Costello in the Big Brother Watch case, who talked about a sea change. He said digitalization, it's not just a continuation, it's a sea change. And we need to revise a lot of the thinking we have today. And up until now, in most countries, the general line of thinking was digitalization is just a new form of communication, or is just a new form of doing things. While actually today really seeing that it is causing very new issues, where you can't just align it with issues that we were dealing with classic crime. Deepfake is a very clear example where the standards we're having today, or the rules in our criminal codices or our criminal provisions, simply cannot be translated to deepfake. And the same is true also for our rules on criminal procedure and checking the reliability of evidence, where there as well we have an issue if we're simply translating the rules that we have and that were drafted for very different kind of types of crime to new types of crime. And I'm looking there as well to our rules of exclusion of evidence, where reliability, accessibility, transparency, etc., should really become a standard. And I think that we need to revise our legal standards if we don't want to run into problems in the future, and that we are really missing. And I think that would be my conclusion, what we're really missing, and it will help both prosecution and the defense, is that we need to have standards for the products we're using, the software we're using on the one hand, but also needs legal to use.
Okay, thank you very, very much, Catherine. And I think there's two, again, important takeaways. One is that you as speakers all seem to have certain predictive capabilities, because some of the questions that have been coming up have already been dealt with in the further parts of the presentation, such as, for example, what to do if the evidence that would want to be used is either not reliable. You addressed that very clearly in the second part of your presentation, the dangers of that, or if it would mean that certain tools would have to be displayed. So just to say that, that's the first part. And the second is that it is a perfect bridge again to Erik. I'll come to that in a second. I would just like to point out, Catherine will have to leave the panel in about 10 minutes because she's got another engagement also at CPDP. So in case we do not manage to get back to you already now, thank you very, very much for your presentation and the insights. We will pick up them also in the discussion, okay? And with that, Erik, now finally it has worked, Erik Modin from the Danish Police Academy. Catherine mentioned the issue that we have the question of which devices are good, what is reliable that comes in from third parties, but then we also have the human dimension of the training of the ones that have to apply all of these. I don't know to what extent in your training capacity at the academy you also address these things, but we are certainly very curious to hear how you deal on a day-to-day basis with this challenge between digital forensics and the fundamental rights. Thank you very much for being patient and that you're finally here. I'm happy to give the floor to you. Thank you.
Yeah, thank you, Markus. And and thank you, Catherine, for mentioning the Danish issue regarding phone data and maybe we'll come back to that one. First of all, my partner, Malte, was supposed to be here as well, but he missed it because of technical issues. So I will be speaking for both of us. And yeah, I represent myself primarily, but I'm also working in the Danish police as a superintendent. I've been working several years with training police officers, and now I am head of a intelligence unit where we are trying to walk the line of intelligence-led policing. And what we're going to walk through today is a perspective is from practice, and this is was supposed to be a dialogue between me and Malte, but now it's only one person, so I'll do it myself. And then I'll try to take you through the journey of what goes through the head of a police officer in the field, and combined it with exactly these new kind of evidence from the digital sphere. So yeah, and I don't know, can I get the presentation? Do I need to push this button? Yes. So we need to talk about Walter and his journey to Denmark. Walter is this guy who comes from a country in Europe, and he decides to go to Denmark. We don't know if it's like he's going to be a guy who's going to do something criminal in Denmark, but he's traveling, and he will meet different kind of law enforcement at his journey. And then this would be set up through like the issues which look a lot like the issues that Catherine also mentioned, where the data is stored and what the police actually can access, and what we're going to do about those issues. So this is Walter, and he's on his way in his car, and he's going to Denmark. First of all, he will meet the Danish border, and right now there's like this massive control at the Danish borders because of the COVID-19 situation. At the border, he will be registered, and he will be controlled. We will control like his passport, and if he has legal, or he has the right to go into the country. And then we will. The car would be registered in the ANPR system, which is the Danish license plate reader system, and that's actually what we get. We get this data from his entering the country. As a leader in the police, my challenge to the police officer at the border would be, can you please tell me if Walter is the guy that I need to look at? And today it's still based on the stomach feelings and like the normal bias policing stuff that some of you maybe know, that the police is like, okay, my experience says that this guy looks like a methamphetamine producer or smuggler. But that's in a perspective of legal and justice. It's not like, it doesn't give me the probable cause to start up an investigation. So I need more. And that's where we are trying to look into different kind of data set. For example, the ANPR system. For example, I will look into the travel pattern. So could this guy have a suspicion pattern? And yes, it could, but the pattern could also be similar to a courier or a guy who works in Denmark and lives in Germany, and all that stuff tells us that this is where we are now. It's of course the future maybe would show us some other stuff, but not right now. It's not possible to use the ANPR system to point out like who are we supposed to start an investigation on. So then we could also look at his prior conviction, and this is an important part that most police officers at the streets maybe doesn't agree with, but it's like prior conviction does not give you probable cause. So this is not a way to start up an investigation. So even though that we can get some kind of data, we still need to have qualitative assessments, and we need to have more intelligence. So I need to have put something on this kind of data that I'll get at the border control to start up an investigation. And in my perspective as a police officer, but also as an academic, it's a place where when we start to discuss this, we actually try to put more rights into the human being instead of just use the bias policing or the gut feeling. So that's actually an argument for more data and using the data in everyday policing as well. So, oh, sorry, can you go back again? There's some delay. Yeah. So, of course, when Walter he enters the country, I could also use OSINT data set. But from my perspective, there's two ways of doing this. So I can see where his connection and his network and all that. And this is a point where this data is not the police collected data. It's data from private companies. And it's also when he entered the country, we have these ANPR systems and the border control, but actually the most data that are relevant for this guy is collected by private companies, Google, phone companies and all that. This build up the same point as Catherine was saying, that this is the data that I need for the further investigation is collected or stored in private companies, and when I get them, they are put into some filter or some analysis, so I don't get the raw data, and that could be a problem. And again, in Denmark, we have been using a lot of money on different kind of private developed tools. For example, Palantir, it could be IBM, Esri, all these kind of companies that provide police agencies with software. When I mention this, it's they are also private companies who stores both public data and police data. And one issue with that is that then they put it together for me, and my police officers at the street or in the analysis offices, they need to understand what they are doing with the data, and this is put into private companies. And I know that I think this is just something I would point out as an issue to secure that I can use this kind of data to to get the probable cause to start up an investigation, for example, or do something else in the policing matters. Yeah. So the main perspective, which I think is something that the most of the other speakers will agree with, is that AI and big data cannot stand alone, and we have there's a danger of this data that we can over rely on the data. And the case from Denmark with the phone data is a huge and great example of when we're not critical enough of the data that we use in our investigations and in the courtroom. Also, sometimes it sounds like the discussion about big data and AI is are you on it or are you not? Then my opinion is that it's here. So we need to be aware of that, and we need to have more democratic control on these kind of tools or these kind of thinking, and be aware that this is not a market that only should be placed on private contractors. So that's a main point from my perspective, is that we need democratic societies to build capabilities and databases with legal control and restrictions. And I think that's the same issue. So the same main point as in Catherine's presentation about transparency and legalization. So yeah, I hope I went through it. It was like some of the points was modest, but that was the main point from my perspective.
Thanks, Erik. And if you wouldn't have said it, I think no one would have even realized that you were karaoke for the part of Malta. I think you very clearly showed both perspectives. I'm sorry that we damaged a little bit the storytelling that you had foreseen, but the important thing is also the takeaway at the end. So I think we have like a converging opinion there that pure outsourcing in this field is not so maybe not so easy because of the problems that can come with it. And it leads us back to what Markus said at the beginning, that that's one of the reasons why authorities that not by nature are in the R&D start getting involved in the R&D. So maybe one of the questions I would put forward is also in terms of capacity. Is this sufficiently happening? We heard that it's very different in different member states. Is there enough resources going into this capacity development on the side of authorities? Maybe we could start with you, Erik, just briefly, because you said it is necessary, but is there also the means to do it, to have control, or are we still at a point where we have to totally rely on the market?
In my dreams, I would answer that yes, we have the capabilities, but it is so expensive for public systems to invest in these kind of developments. So what I think that we need to do instead is invest in people that are able to be critical about these kind of stuff. So for me, it's like it's not only the hardware or the software development. It's also a mindset, which is something that we could put into education of the standard field officers, but also put into like a standard for when we use these kind of systems. We have people whose job is to be critical. Mm-hmm. So I think that could be some solution on it, but I mean, it costs a lot of money to develop these kind of tools. So yeah.
So it's the human factor in a second sense. Markus, what's your take on that? Because I think you have an oversight also how much efforts you've already been putting into this in the last year.
Yeah, I totally agree with what Erik said, but actually I think the perspective could also be taken from a different angle. Like, it will cost us a lot of money not to invest now, because I think if you just go through the figures, it's 100 billion euro per year estimated cost of cybercrime in Germany. So if you just look at the impact of digital crime on a society, the amount of resources going into research and development, into training, everything that was said by Catherine, by Erik is completely correct. We need people that are critical. We need people that are tech aware. We need people that have the deep understanding where it is. And we need, I would like to stress this one, we need to close the digital gap between prosecutors and defense lawyers. So all these questions apply, but nevertheless, we have to do the investment as a society and as the government authorities ourselves, because we will never overcome the state of relying too much onto private actors if the core tools we are using are not under our control. And I think that does not mean that all the researchers have to be government employees, but government agencies have to build a network of trust with academia, with private actors, in order to be able to understand, to develop, and finally to decide what kind of tools they want. Don't buy what others suggest you should be buying, but buy that what really tackles your questions and what really fulfills your individual prosecutorial needs. So I think it's both investing and also building a network of trust.
Thanks for that. We have a number of questions in the chat. Quite a few are revolving about the panel's view on predictive policing. I would step those back a little bit, because we actually were talking about how tools can be used when actually crime has occurred and or is being investigated. So predictive policing, I think, is another layer. But maybe we have a minute at the end on that. But the other point that was made, and I just don't want to give the impression that we're suppressing that opinion, is the use of the expression child pornography. I think it's safe to say, Markus, that you also indicated that yourself. We're all aware of the fact that child pornography may insinuate it's similar like pornography, and therefore that there's agency of the ones involved, but that child sexual abuse online, there's a big discussion always whether that should replace the expression. But I think that was just a question just to add that maybe the expression child pornography today is no more fully appropriate, and child sexual abuse, like you use it as well, would be more appropriate. I think we can take that. But what is really important is that's 2 or 3 questions go around. How big is the fear that using these tools will maybe lead to problems in court afterwards? A, by being questioned about whether the evidence was reliable. B, maybe the defense saying, well, you built your whole case on data, even if you're not using it for the conviction, but you're building your whole case on data which is kind of dubious where you got it from. And maybe third aspect, what about if then you would have to reveal the functioning of the tools to an extent that you might not want to do it? A case was mentioned from the US where the FBI simply dropped a child porn case and said, we don't want to discuss how we did it to come to these conclusions. How are your perspectives on that? Maybe Markus, you start.
Yeah, I've actually seen very few cases that were built purely on data. I think the biggest role the data analysis and the data evidence plays is in the role of gathering probable cause or enough evidence to actually start more or less traditional investigation, like raiding a suspect's house, conducting interviews with people, and so on. So from my experience, at least now, the majority of court cases in the end relies on traditional evidence. And the data evidence is building the path to traditional investigations, which does not mean that the meaning and the importance of data evidence should be underestimated. Because if you're going the wrong way in the very beginning of an investigation, then it's really difficult to correct these errors. So I think we are at least now not in the state of that the risk is that there will be wrong convictions because we are not relying solely on data evidence. If there would only be a big data result, this guy has to be convicted of child sexual abuse, I don't think that would be accepted in court. With regard to the tools, yes, it's of course a question, but it's not an unusual question for prosecutors. We always have been relying on secret investigative measures like covered agents that don't get revealed in courts. And in the end, it's up to the court to decide whether this evidence could be trusted or not. What Catherine said, I think, is the right direction. We need to put into place standards that in the end, we can guarantee that the way we seized evidence, we analyzed evidence, follows the standards. And this would be a baseline and a fundament for the court, for the defense, and for the prosecutors to agree on this. These standards can be accepted. Up to now, there is still a lot of work to be done. But in the end, we are more or less still living in an analog world in the courtroom. This will change in the future, and it's now to decide on the rules that we want to follow in the digital courtroom.
Thanks, Markus. Erik, maybe briefly also on that point.
Yeah, but I could just say that I agree with Markus, and I was thinking the same. But it's like, as an example, if a guy like is suspicious about he's suspected by drug smuggling, I need to have like physical evidence, search the car, find the drugs, and then I can go back and see this guy, he drove to Germany 7 times last week. this doesn't mean that he did drug smuggling 7 times last week. It could be. So it's an indication, and I could be interested in looking more into it. So we are not at that place now, and that's I think that's in people's in a lot of people heads, even in leaders in the police, they think that this is like, so we are there now that we can use the ANPR system to like to check that, okay, this guy, he did it 7 times, but in the courtroom we're not there yet. And I think that's also something that I will point out in this discussion, is that we still need to like we are still building cases in the physical world. And I think that Markus has a right in the saying that if we need to do something stand up with this, we need to do it now before we get these kind of questions into the courtroom, and then it would be, yeah, it would be a difficult way to, we could get in some troubles in that way.
Okay. Thanks. We have to wrap up, so we've got only half a minute left. But Georgios, maybe on that, your last point, the standard development. Do you see the solution for the fundamental rights balancing in the development and reliance on such standards and certifications of such standards?
Well, yes, of course. You were talking about the court stage, so I would go prior to this, because in case of phenotyping, we are not there yet. Phenotyping related elements cannot be used at the court. However, of course, we could have authorities that could provide for standards, and I mean expert authorities, maybe from the private sector, or perhaps we could have authorities who could engage in counter testing to assess accuracy or reliability of the results on behalf of the unknown. Thank you very much.
I think, I hope that you can actually hear or not. I was at least cut off. I don't know whether it was Georgios that was cut off or not. I hope that you can all hear me. A brief nod. Okay. As we have to wrap up, I couldn't get the last part of that, but what certainly has been shown, and also the questions, is this is a topic. It's good that we set the scene for that this time. We're going to get back to it in CPTV 2022, I'm sure. Actually, there's a panel following ours in Online Space 3, which also deals with this topic from a slightly different perspective. I would really, really like to thank all of the speakers, including Catherine, who's no more online. It was very, very fruitful. Thanks a lot, and especially also for sticking with us due to the technical glitches. Nonetheless, it worked out very well at the end. Thanks a lot from my side. Looking forward to see you all again in different capacities. Thanks to the organizers. Bye for now.
Thank you very much.